Pradeep Kumar, President of the Advocates Association, Shri Ashok Singh, President of the Bar Association, senior advocates, all of you gave me so much of my learning, which has made me what I am today. Listening to you, all the members of the bar, members of the registry, ladies and gentlemen. I thought I shouldn't speak from a prepared text for this morning and speak from the heart for a few moments. The initiatives which we showcase today reflect both on the past and the present of the High Court of Judicature at Allahabad. They reflect on the position of this High Court in the life not only of the state of Uttar Pradesh, but of the entire nation. They represent a vision for the future. So in coining all that we have done in terms of the infrastructure for this great High Court, in preparing the book called the Courts of Uttar Pradesh, we dwell on what Uttar Pradesh is today as a legacy of what happened in the past and the past on which we have built so much, the past which we have discarded to a certain extent, because all our courts began in the legacy of the colonial period. The colonial period reminds us that law can be used as an instrument of justice, but it can be also used as an instrument of oppression and injustice. It depends on whose hands the law is wielded. You had the same Indian Penal Code which was used from 1860 and which is still used today until the new legislation is enforced. But the same law which was used to jail the freedom fighters, to torture the opponents of the regime, is hopefully being used today to protect the rights of citizens in the hands of an able bar, which we have in the Allahabad High Court, fiercely independent lawyers, judges who have come from the bar and from the services, who use that law to dilute the rigors of the power of the state. So this is clearly a reminder to us that it is for our generation today to ensure that the excesses of the past, most of them prior to independence, but many of them even after independence, such as during the years of the emergency, are not replicated against in free India. These initiatives today are also the product of people who have gone before the present generation. I know that Justice Bhosle, who is here, was the moving spirit behind Courts of India when he constituted the committee during his tenure as the Chief Justice. Justice Bhosle is truly a people's man. As Brother Mishra was telling me, he is always present for every important occasion of the Allahabad High Court. I have to learn something from his book because I am coming back after 8 years. But 8 years was too long for me. So what we are unveiling today represents our vision for the future of the Allahabad High Court. Let me briefly dwell with each of these initiatives and share a few thoughts which I have today. We have inaugurated the Arbitration Center of the Allahabad High Court. We have provided a venue for the arbitrations to take place. For those of you who have done little work on arbitration, you know the distinction between the venue of an arbitration and the seat of the arbitration. What we have provided is an efficient venue for arbitration. But is this center only a venue for arbitration? Arbitrators otherwise go and sit in 5-star hotels. They go and sit in centers for arbitration. To my mind, the setting up of the arbitration center at Allahabad is venue plus to use today's terminology. Of course it provides a venue, it provides a place where people can come and congregate. And in providing that beautiful space, I must compliment all the judges of the Allahabad High Court, the people in the Public Works Department who have collaborated with the High Court in setting up the center. We have conference rooms, we have huddle rooms, we have a locker room, a cafeteria, everything that is required for a day of arbitration. But there's something more. And that is where I would like you to develop this whole concept. First and foremost, I am extremely pleased to learn that the name of the center is not the High Court of Judicature Allahabad Arbitration Center. It's called the Arbitration Center Prayagraj. Why? What is the significance of it? Is it just another name? No. Calling it the Arbitration Center of the High Court would give the impression that it is an arm of the Allahabad High Court. That it's an arm of the state, because we are not part of the government, but we are all part of the state, the nation state. The business community in particular always has some reservations when arbitration is associated with the imprimatur or the stamp of the state. Because the essence of arbitration is party autonomy, the independence of parties. That's why they choose their own judges. In the High Court or in the Supreme Court, our lawyers don't choose the judge. They will appear before. So I've also found that there is a bit of forum shopping which goes on. But lawyers don't choose the judge. In arbitration, litigants choose their own arbitrators by nominating their own arbitrators because they have faith in those arbitrators. And the presumption is that arbitrators who are nominated by litigants are not their mouthpieces. That is theoretically the foundation of arbitration. So the idea of having an arbitration center called the Prayagraj Arbitration Center is to truly indicate that this is a center of arbitration which is not dependent either on financing or support from the High Court. So the High Court stands behind this initiative. We as judges are facilitators. We stand behind this initiative. But in creating this venue, we also want to create a process of arbitration which is efficient. Efficient in terms of cost, efficient in terms of timeline for arbitration. If arbitrations were to take as long as a suit takes in a court, then why would people go to arbitration? If they have to spend as much as they have to spend in a suit, why would they go to arbitration? Setting up this center is also a sign of accountability. That arbitrators have to be accountable to the community whom they serve. They can't be accountable if they sit for 2 hours and charge the fee for the whole day. I know I have been criticized for having interpreted the 4th schedule to the Arbitration and Conciliation Act as imposing a cap of 30 lakhs on the fees which arbitrators can charge. Our mission in literally interpreting the provisions of the statute was to ensure that this is what Parliament has laid down. If you want to alter the provisions which have been made by Parliament, Parliament is free to do so. But we also said that you can charge for a counter claim and a claim separately, because a counter claim is a separate suit. One of my learned brothers felt a little differently on counter claims. So we are not just replacing one form of dispute resolution, namely resolution in court, with another form of dispute resolution, namely court-style resolution in the hands of arbitrators. In the choice of arbitrators, many of the arbitrators, most of the arbitrators today are retired judges who of course do a remarkable job. All of them are very highly experienced. But let us look beyond just judges in the canvas of arbitration. And that is where I want to appeal to all the learned and respected senior members of the bar who are present here. Many members of the bar do not become judges for a variety of fortuitous circumstances. Maybe you are not asked at the right time. Maybe a person whom you felt is a competitor got elevated to the bench a little before you. Maybe there were family circumstances bearing on economic resources. Many people join the bar late because they have had to combat personal difficulties in the early part of their lives when they took jobs somewhere else, and when the situation stabilized financially for the family, they took to the bar. So they didn't become judges for a variety of reasons. But the wealth of experience which our senior members of the bar have today can surely be contributed in the arbitration space. When I have to impose costs in the Supreme Court, I'm always very wary because my assessment of costs is very different from what the realistic costs today of litigation are. Very often when I impose costs, the lawyers laugh and they say, please allow us to give you a realistic assessment of costs. So you as members of the bar know the feel of reality on the ground, which we as judges over a point of time, over a period of time, may not necessarily have. And I do believe that by setting up the arbitration center, we can encourage more and more members of the bar to contribute to the arbitration space. We can train the younger members of the bar. This will be a training ground for them to become judges of the High Court in future. I have found, for instance, when I appoint a lawyer in their 30s or in their early 40s as arbitrators, many of them complete the arbitration in record time efficiently as a call of duty to the court. So in the choice of arbitrators, let us broaden the canvas of arbitration by getting people who are acceptable, engineers, chartered accountants, young members of the bar, senior members of the bar. Because these are people who have the voice of the community, who have the faith of the community. So all in all, so far as the arbitration center is concerned, it is important now to frame rules for the arbitration center. Create a society which will be professionally managed and professionally run. And the entire arbitration center should be handed over to a professional body of persons consisting of judges, consisting of lawyers, consisting of eminent citizens of Prayagraj who have distinguished themselves in different walks of life, so that by professionalizing the center for arbitration, we will indicate that as judges of the High Court we stand behind this center. Of course, this is all due to the vision of today's judges. But while we stand behind this initiative, the success of the initiative will lie in how much we really are able to professionalize arbitration within the state of Uttar Pradesh. Brother Bindal rightly mentioned how much it will be used is a moot point. But let us also remember that we are today using a facility. The premises of the High Court of Judicature at Allahabad was set up over 100 years ago. So those who created that infrastructure had the vision to create infrastructure which could be used even 100 years later. So when Justice Bindal and his committee decided that instead of having a VIP guest house, we will have an arbitration center, this has been done with a great amount of foresight. Irrespective of how much it is used today, we have created a seed for the future. Uttar Pradesh is attracting investment. As the state grows from a predominantly agrarian economy into a market-based industrial economy, there will be bound to be more and more trade, commerce, investment coming into this state. And trade, commerce and investment relies on certainty. It relies on the rule of law. It relies on the existence of objective standards for dispute resolution. In creating this, we are sending the message across to the community that what happened in the more developed states like Maharashtra or Karnataka or elsewhere in the country is now being replicated in terms of infrastructure and rule of law, which will sustain the confidence of our communities in the new horizon which we would like to create for this state. So I compliment everyone who has been associated with this new infrastructural growth in the High Court of Judicature at Allahabad. The second aspect which I want to stress upon today is the importance of the infrastructure which is being created for the district judiciary. The district judiciary truly is the cornerstone of the administration of justice in every state in the country. The district judiciary is the first point of contact when a citizen has a problem, whether she has a dispute about maintenance, whether she has been thrown out of her house by in-laws and she has to seek a remedy under the Prevention of Domestic Violence Act, or when senior citizens have to move for securing their own rights in the face of a family. So the district judiciary is the first point of interface of our citizens. But here I have a few concerns which I must share with you. My first concern is the large pendency of criminal appeals. Brother Mishra, Brother Manoj Mishra, Brother Pankaj Mittal, Brother Vikram Nath and I, all of us belong to the judiciary in Allahabad. We all belong to Allahabad. Some of us may have different birthmarks. My birthmarks go to Maharashtra, but I belong to Allahabad as well as I do belong now as a Chief Justice to the entire nation. Across our court, judges constantly voice this concern. Why is it that criminal appeals are taking so long to decide? Why is it that the bar is very eager to decide questions involving bail but not willing to argue criminal appeals? I think all of us need to sit together to resolve this issue, because this is doing disservice to our state, the large pendency of criminal appeals. This is not undoable. This is not a situation which has gone out of control. Several other states in India, including the state of Tamil Nadu, had the same problem which we have today. But they found solutions to the problem. Now what happens because of the large pendency of criminal appeals, particularly in the High Court, is that judges are compelled to grant bail, particularly in the Supreme Court, no matter how heinous the offence is, because of the realization that if you don't grant bail today, the person will probably die in jail or have served out the sentence by the time that the criminal appeals comes up. That's not good for the system either, because you no longer just look at the rights of the accused, you also look at the victims of crime. But we as judges have no choice but to grant bail for the simple reason that we realize that these appeals will never come or see the light of the day. But this has another consequence, which is of equal greater concern to me, which is the inability of our courts to grant bail to under trials. Repeatedly in the Supreme Court, and I am not giving you Newtonian science, small offences, petty offences where people have been in jail for 1.5, 2 years as under trials, they run to the Supreme Court to grant bail. We have dealt with cases where an FIR has been stayed by the Supreme Court, but the accused is not granted bail for over 2 years thereafter. And people are before us asking, please grant me bail. Now there is a fear psychosis in our district judiciary. And I'm sure both the judges and the members of the bar will agree with me. And I'm not being critical at all. How can I be critical? I'm here because of my life as a lawyer, and I'm here because of my life as a judge. So I'm not being critical, but I'm asking you to introspect. Why is the district judiciary so fearful about granting bail? The district judiciary is fearful about granting bail because over a period of time we have created a culture of subordination between the high courts and the district judiciary. We have not created a footing of equality between the district judges and the high court. You know, the whole process of inspection, the administrative judge, it wreaks fear in the minds of the district judges. When you look at the young judges who are joining the district judiciary, and in my tenure as Chief Justice of the Allahabad High Court, I travelled across the state. I found a marked difference. The younger generation of judges in the district judiciary, so bright, so full of hope, they would talk to you as if they were talking to a friend or a member of the family. The more senior judges, so sober, so quiet, so withdrawn, you had to draw them into a conversation. They would be very reluctant to speak to you. So that shows you the difference between the young and the old, in the senior in the district judiciary. I think that has to change, and the duty to do that lies on us as judges. So this culture of subordination has to change. We are having a conference in Kutch in the next few weeks where we are inviting about 150 to 200 district judges from all over the country to talk to me and my two senior-most colleagues about what the district judiciary feels needs to be done for them. We want to hear their voices, and hopefully we will have a conference thereafter in the Supreme Court, having about 800 or 1,000 district judges from all over the country. The idea is to hear their voices, allow them to speak, allow them to tell us without a sense of fear. I'm very happy to know that the infrastructure of the district judiciary is going to be improved by having 10 integrated court complexes in 10 different states, in 10 different districts in Uttar Pradesh. Our court should not be known by
देश विदेशातील प्रत्येक घडामोडींचे लाईव्ह अपडेट मिळवण्यासाठी आता साम टीव्हीच्या सर्व सोशल मीडिया प्लॅटफॉर्मला लाईक, फॉलो आणि सबस्क्राइब करा. तसंच सर्व नोटिफिकेशनसाठी बेल आयकॉन प्रेस करायला विसरू नका.